Many thanks for staying with us on the program. Now, Atiku, Obi, and the Allied People Movement had filed separate appeals at the Apex Court, seeking to nullify the outcome of the February 25, 2023 presidential election after the Presidential Election Petition Tribunal upheld Tinubu's victory. Now, the Supreme Court communicated the hearing date through notices sent to all the parties prior. Atiku and Obi had faulted the verdict of the tribunal and subsequently filed appeals at the Supreme Court, which of course we know as the Apex Court. The PDP candidate also filed for permission to tender a copy of Tinubu's academic records released by the Chicago State University, CSU, USA, which he said show that Tinubu submitted a forged certificate to the Independent National Electoral Commission, INEC. Now, from then till now, a lot of people have said that it is impossible to present a new discovery, while a case is still on. But some other people say that it's legally possible if the documents were not within reach as at the time that the petition was filed. So today we're going to get a wider view, a broader perspective of what's happening, because of course we'll be joined by a legal mind, Barrister Jide Ologun, a legal practitioner from Ogun State. Thank you so much, Barrister Ologun, for joining us.
Pleasure to be with you.
It's a pleasure to have you join us as well. Now, Barrister Ologun, I'm going to start with this question. We're having a lot of petitions being filed, against both parties now at the Supreme Court. I guess it's safe to say that, or it's safe to ask that, why are these findings, or why were these findings not done before the presidential election took place? Why is it that we didn't investigate everybody's academic background? Why is it that we didn't investigate everybody's school and all of that? The documents were submitted to the INEC, but why is it that no further inquiry was made until now that petitions are being filed?
You see, that must have been a fact of not being proactive, because in legal matters like this, you are expected to harness all the resources you need to win your case in court. And of course, primarily, the Supreme Court, which is the apex court in the land, is not a court of evidence. So these documents have been presented at the tribunal level. But having said that, the Supreme Court has the discretion to admit this again and consider it. But that discretion is so tight that majority are of the perception that it won't be entertained. And then we have 7 justices at this level. We had 5 justices at the tribunal level, which of the Court of Appeal institution platform. So we are monitoring, because we don't want to preempt what happens from the Supreme Court, particularly knowing that I'm a lawyer myself. But I expect, like I mentioned, that the 7 justices will look critically into the matters before them. But having said this also, let me state that under the Nigerian Constitution, the minimum requirement for any candidate seeking the office of the presidency is a school living certificate. You see, so we may need to, again, after concluding this matter, visit the laws of the land, particularly our constitution, if we want to upscale. But this argument is very tight for opposition, I suppose, because when you look at the candidate, the question is not whether he attended Chicago State University. The issue now is that we forged a document. And if you look at Section 131 of the Evidence Act Nigeria 2011, the one who alleges has to prove. And like rightly started when you asked the question, is it the time to bring in this matter? So we are watching and monitoring, and the Supreme Court has set a date to decide on this, and that date will be communicated, because from the decision date of the tribunal, the Supreme Court has 60 days to decide this matter before then. And we all know that since 1963, when Nigeria became a republic, the Supreme Court is the highest court in the land. So we are waiting for the decision of the Supreme Court. And I want to advise that we don't get carried away by sensationalism and sentiment. The law is law. And then all the sensationalism that attended the tribunal stage of this matter saw how it all ended. And we expect that these 7 justices of the Supreme Court, with the aggregate experience they have, will do justice to this matter.
Right. Barrister Ologun, now we're definitely going to come back to the justices of the Supreme Court, but permit me to circle back to what you said, and please help us clarify. You did mention that the judges would be, would use their initiative, whether or not they're going to admit this new evidence. But if we're looking at the Constitution, and based on precedents, of course, somewhere in the Constitution it says, permit me not to quote verbatim because I don't exactly know it, but just to paraphrase, it says that if the evidence was not exactly at the disposal of the petitioner at the initial stage, and eventually they're able to get it, it should be allowed to be registered, or it should be taken cognizance of. So in this case, it's obvious that this document, this new evidence, wasn't at the disposal of the former Vice President Atiku Abubakar. So what exactly is stopping it from being admitted as evidence, and why exactly do we need the judge's initiative for that?
You see, at the tribunal level, the issue of Bola Tinubu's credential came up, and you would have been expected at that point to present to the court all the exhibits, your evidence, bring up your witnesses, and while delivering their decisions at the tribunal level, the justices mentioned some lapses that came on the part of the legal representatives before the tribunal. Don't forget, there were about 89 senior advocates of Nigeria and some other lawyers. And even during that process, some of them filed out of time, and which people refer to as technicalities. But the discretion of the Supreme Court cannot be ruled out. I am not a only justice in the Supreme Court, but I'm saying they have the power to say, okay, let's entertain this. And they have the power to say, this is too late, and that it cannot hold water. And when we go to court and the justice makes his own position known, all you say, whether you are pleased or not, is that as the Lordship pleases. And the next thing you can do is to proceed to a higher authority and appeal if it is not in your favor. And that is why I advise against sensationalism. The justices of the Supreme Court reserve the right to say, okay, now that this document is coming, let's see what we can do. Beside common law is what we call equity. And the role of equity is to prevent miscarriage of justice. So the justice will look at this and try to ask some questions. How critical is this to the issue on ground? It's not going to be taken in isolation. Don't forget also that while the petitioner is bringing some document to the court, the respondent also has the right of representation. And the respondent have told the Supreme Court that there is no merit in what is being presented to the Supreme Court. And the final decision lies with the 7 justices. And we are talking of Justice Wanu Abaiji, we are talking of Justice Saulawa, Justice Jaro, Justice Abubakar, Justice Emmanuel Agim, Justice Lawal Gaba, led by Justice Iyan Kokoro. So you can see that we have brilliant justices sitting on this. So it's not going to be a decision that one person will take. And we are waiting to see how it will go. And that is why I earlier made reference to the provision of the Constitution on the qualification to contest for presidency. Don't forget that at a point in time also, a pre-trial matter came up during the tribunal, which was that Peter Obi himself was not a member of the Labour Party at the time he was contested. And the tribunal threw that out. So it's for you to present your case before the court. You are not the court. It is for the court to look at the merit of the case and decide. And that is why when you are reading some of these decisions, you hear conclusions like lacks merit, not stand, it's different kinds of expressions. And so here we are, this is the final stage in this battle, the Supreme Court. And after the Supreme Court, all parties are expected to, take the verdict. And like I said, while analyzing the matter when it was before the tribunal, there are three options: to affirm and confirm the victory of Bola Tinubu as the president of Nigeria, or to nullify his victory and ask for a rerun, or to nullify his victory and ask that if any of them has been declared winner, talking about the petitioners now, that they should be sworn into office. So those are the three basic options, but they will be prompted by giving consideration to the laws of the land, the discretion of the court. So that is where we are right now.
Okay. Now, coming back to the justices presiding over this matter, following Justice Musa Mohammad's retirement, we find that there's been a reduction in the number of justices slated to oversee the case. We do understand that some of them had to step down because of conflict of interest, but can you give us a broader view of that? Why is that? Why exactly is there a reduction in the number of justices?
Constitutionally speaking, we're expected to have at least 21 justices in the Supreme Court. And I think in year 2022, we were able to have about 20. But some have passed on, some have retired. And, the former Chief Justice of the Supreme Court resigned from office when there were allegations of corruption and some shake-ups within the system. So right now, we do not have the substantial number of justices in the court. So what that would do is to put pressure on the court. But by and large, the court has succeeded in presenting 7 justices to sit over the case. And if you look at the justices, they are spread across the country. And so one is expecting that justice will proceed from there. So the issue of having lower number of justices is an administrative issue that must be attended to, because constitutionally speaking, we're expected to have the Chief Justice and 20 others, supporting him at the Supreme Court. But right now, due to the transition of some of them to death and resignation and of course retirement rather, because the retirement age is age 70. So all these things can be attended to by the laws. And of course, more justices can be elevated from the Court of Appeal to the Supreme Court. So, but I do not expect that this will affect this assignment, because already we have 7 justices constituting the panel and not actually read about conflict of interest. But by and large, Supreme Court needs more hands, minds and brains to complement the required workforce that we need there as a nation.
Right. Barrister Ologun, now the proceedings continue today, and many people are somehow expecting a final verdict. But we know that's not how it works. I mean, the proceedings might resume today, but we're not going to get a final verdict immediately. Like you said, there's so many processes, the documents have to be compared and all. Can you walk us through very quickly what the processes are up until when we will expect a final verdict from the Supreme Court?
You have presented your matter to the Supreme Court, and the justices will look at it, 7. So they are likely to have a night vigil and things to consider, present your own views, benchmark it with the laws of the land. And constitutionally speaking, the highest court in the land has been given the mandate to pronounce. Nobody is saying there won't be arguments, there won't be conflicts, but you bring it to the court. And at the first instance, the matter emanating from the most recent elections in Nigeria, proceeded to the tribunal. And if you look at Section 65 of the Electoral Act, the gate is kept open there. It's a constitutional and fundamental right of any party who is aggrieved to go to court. And the 5 justices listened to them, gave them the opportunity of fair hearing and representation, and came to a decision that, okay, we are affirming the victory of President Tinubu. And of course, the gate is open for those who are not satisfied with that to proceed to the Supreme Court. So right now in the Supreme Court, I think we have 3 parties there, the Labour Party, PDP, and one other party, And of course, the court will consider what has been presented to them. What is quite dramatic now is that a document has been procured to present to the court, and now we have a fresh evidence. So let's see if the Supreme Court will say at this level we can admit this evidence and consider it or not. But I mentioned earlier, the case here is not that Bola Tinubu did not attend Chicago State University. And of course, we tested the jurisprudence of the US by going there. And I think I commend all the parties for strengthening the muscles of democracy, but that is the spirit of democracy. But having said all this, all we have read in the newspapers, all we have heard in the news, different permutations, Supreme Court of Nigeria has the final say on this fact. Like I mentioned earlier, after 1963, if you are not pleased with the decision of the Supreme Court, then you may take your matter to God. So after the Supreme Court, then we can now rest and move forward to engage issues of governance in the country. So permit me to appreciate all those who have taken the efforts and rolled out the resources to test our democratic processes. And I hope that the National Assembly is monitoring keenly, because if you look at Section 4 of the Nigerian Constitution 1999 as amended, it stipulates that the National Assembly shall make laws for the peace, orderliness, and good governance of Nigeria. So we need to fine-tune our laws. Like I said earlier, the issue of credentials, qualifications, and things like that, it can we be specific, make firm pronouncements. The laws of the land are subject to amendment as development demands. Society is dynamic, and your laws can be transformed to keep up the pace of dynamism. So here we are right now. I'm just advising, I will not follow the trend of media adjudication or sensation going on online and things like that. Supreme Court is there, and when they consider all the matters presented before them, they will come out to conclude to the world what their findings are and what their decisions are. And I have given us a clue here. There are 3 clear options. So let's wait so that we don't run far of the jurisdiction and the right to, fair hearing and respect for the discretions of the Supreme Court.
All right. Okay, finally, Barrister Ologun, talking about the affairs of Nigeria in its own, would you say that this is a major distraction from following up with reforms? Because according to this present administration, Tinubu's administration, one of the things he said when he resumed office was that he was going to hit the ground running. And from the things that he's done, we can say that he did just that. But would we now say that these court proceedings, the back and forth, is a distraction from following up with the reforms, or does it not in any way affect it?
Humanly speaking, it's a distraction. And that is why in our constitution, there's a provision for immunity for the president and the vice president, governors and deputy governors of states to prevent unnecessary legal matters in courts, particularly prosecution, that may distract them. But also, having said that, as we speak now and until we come back from the Supreme Court with the final decision, Bola Tinubu is President and Commander-in-Chief of the Armed Forces, going by the decision of the tribunal. And so action can still be going on to deliver good governance to citizens. And of course, if the final decision from the Supreme Court is that the victory of President Bola Tinubu is confirmed, then it can now have a greater sense of peace to engage the issue forward. Because I mentioned, humanly speaking, it is a distraction. And that is to tell us also that he also is subject to the decision of the Supreme Court. So the judiciary appears to have the ace in this matter, subject to the dispensation of justice. And until that is finally dealt with, he cannot claim that he is at rest, really, because it's a very sensitive matter. But we look forward to, beyond the final decision of the Supreme Court, that our leaders will rise up and reposition Nigeria on the path of prosperity and begin to implement what we have in Section 14, subsection 2 of the Nigerian Constitution 1999 as amended, that stipulates that the security and the welfare of the citizens shall be the primary purpose of government.
Right.
And those are my submissions for now.
Okay, Barrister Jide Ologun, legal practitioner from Ogun State. Thank you so much for joining us on VSA.
Thank you. God bless Nigeria. Have a lovely week.
And you too. Thank you.